On July 4th, 2023, Independence Day, Judge Terry A. Doty of the U.S. District Court for the Western District of Louisiana entered a historic injunction against the White House and other federal officials. This injunction prevents them from, quote, urging, encouraging, pressuring, or inducing in any manner the removal, deletion, suppression, or reduction of content containing protected free speech posted on social media platforms. Judge Doty's opinion contains 82 pages of detailed factual findings, supported by 577 citations of the evidence, which is drawn from roughly 20,000 pages of the federal government's own emails and communications with social media platforms and 6 full-length depositions. In its recently filed stay motions, the government has hardly bothered to dispute any of these factual findings. The Court of Appeals has entered a, quote, temporary administrative stay of this injunction and granted expedited briefing and argument on August 10th. Contrary to some recent suggestions, a temporary administrative stay is, quote, routine practice in the Fifth Circuit. That's a direct quote from the recent decision in N. Ray Abbott, and it does not reflect any judgment of the merits. Today, I want to offer 7 observations drawn from the Louisiana opinion. First, the Louisiana court found, based on overwhelming evidence, that federal officials are the cause of the censorship of the viewpoints they disfavor. The government likes to claim that social media platforms acting on their own would apply their policies and censor all this content anyway. This is demonstrably incorrect. Again and again, the Louisiana court found that the platforms would not have suppressed this speech, but for the fact that the federal officials were pushing for it. The deplatforming of Alex Berenson, the throttling of Tucker Carlson's content, the silencing of the so-called disinformation dozen, which includes Mr. Kennedy, the suppression of much of the so-called borderline, which is, quote, often true content on Facebook's platforms, the censorship of the Hunter Biden laptop story, and much more. All these were suppressed because of the efforts of federal officials. Second, the scope and reach of federal censorship is staggering. As the Louisiana court repeatedly found, it affects, quotes, millions of social media posts and speakers all across America. It affects virtually every American who reads, listens, engages, or posts on social media about great disputed political and social questions that federal censors have stuck their fingers into. Third, federal censorship is ongoing and it shows no signs of relenting. Federal officials' censorship efforts are in full swing and they're expanding to new frontiers. Left unchecked, federal censorship will reach virtually any disputed social and political question over which federal officials want to impose their power. Fourth, the Louisiana opinion shows that federal officials are most eager, most focused on silencing truthful speech and to muzzle the most influential critics of the administration and its policies. Tucker Carlson, Alex Berenson, and many others were targeted not because what they were saying was necessarily false, but because it was the most effective criticism of the narrative line that the administration was pushing at the time. Censorship is not about truth. It is about power, preserving and expanding the power of the censors and the political narratives they prefer. Fifth, federal officials are deeply intertwined with what other witnesses have called the censorship industrial complex. The Louisiana court made very detailed findings about the close connections between many federal officials and that mass surveillance and mass censorship enterprise that calls itself the Election Integrity Partnership and the Virality Project. Not just CISA officials, but White House, State Department, and Surgeon General officials have deep ties to that enterprise. As the Louisiana court found, CISA and the EIP were completely intertwined. Sixth, federal officials don't just dictate the outcomes of specific content moderation decisions. They also directly induce changes to the content moderation policies of major social media platforms to ban disfavored viewpoints in advance. And seventh, the federal censorship enterprise has succeeded in transforming online discourse by rendering entire viewpoints virtually unspeakable on social media, which is the modern public square. This ongoing distortion of the most fundamental American freedom, the right to free speech, is intolerable under the First Amendment. Thank you.
Thank you, Mr. Sauer. Ms. Wiley, you're recognized. The gentleman from New York is recognized for 5 minutes question.
Thank you, Mr. Chairman. Mr. Sauer, did you discuss the substance of your testimony here today with any members of this committee? Yes. Can you turn your microphone on?
I participated in a briefing yesterday afternoon with members of the subcommittee when my testimony had already been finalized.
And were any Democratic members included in that briefing?
I can't say for sure. I don't know all the members who were involved.
You don't know?
I don't know. I'm not as familiar with the membership of the committee as perhaps I should be.
And am I correct that, I'll just note for the record, there were no Democratic members in that briefing. But am I correct, sir, that you are one of the lawyers that brought the lawsuit that we are discussing here today?
That is correct.
So you're a party to that case?
No, I'm an attorney. That's very different.
Well, you represent Louisiana. You work for the Attorney General's Office of Louisiana, and Louisiana brought the case?
That's correct. It would be inaccurate to describe me as a party.
Okay. But you don't decide whether or not your arguments that you make in that case and that you're making here today are valid or not, do you?
They seem very valid to me. The judge will make a decision in our case.
The judge makes the decision, right?
Correct.
Not you. And as you know, the district court did not decide in its opinion whether your assertions are correct, right?
The district court dismissed the pending motion to dismiss by the Department of Justice, saying that we'd alleged sufficient facts to state claims, and we'll have a hearing in late May on our pending motion for preliminary injunction. He has not ruled on that yet.
Just so lay people can understand, a motion to dismiss just says that if the allegations that you make are true, you can continue with your claim. A preliminary injunction will actually address the evidence that you're discussing, right?
That's correct.
Okay. Now, are you expecting that the Department of Justice will appeal the motion to dismiss order?
You would have to ask them. Well, actually, the motion to dismiss order, it's very unlikely because there is no procedural right to appeal that. And so far, they haven't made any attempt to do that. It would be they would have to do that by pursuing what's called an extraordinary writ. That'd be very unusual. That said, I do not speak for them.
Do you read the news, sir?
I'm sorry?
Do you read the news?
Some news.
Are you aware of reporting that Donald Trump's defense attorney asked Republican members of the House of Representatives to intervene in an ongoing criminal investigation into himself in a local prosecutor's office?
I don't recall reading that.
Okay. If that were the case, would you consider that to be called, quote, directing, unquote, that the House of Representatives act on behalf of Donald Trump?
I would have to know many more facts before I'm able to make any kind of judgment like that.
Right. All right. Well, I just wanted to understand, because you talk a lot about directing here, that the government is directing, but then you also say that there's a compelling inference. Now, we lawyers understand that inferences only occur when you don't have direct evidence to support it, so I would also just want to note that.
We have overwhelming direct and
there's no
indirect
question.
evidence.
The sad reality here is that we are continuing to go down this phantom narrative that the White House or the Biden administration coerce social media companies into censoring anti-vaccine and election disinformation and misinformation. Now, we know why that is, because the members on the other side of the aisle believe that that disinformation and misinformation, if it gets out there, is politically beneficial to them. But unfortunately, neither you nor they have presented any direct evidence to support this. But I would actually submit that this hearing is more notable, not because of the topic and the witnesses, including 2 who were too afraid to stay and answer questions, but because of what we are not focusing on. Apparently, this committee is no longer focused on the so-called dozens and dozens of FBI whistleblowers who were supposedly going to show some massive government conspiracy to attack conservatives. 3 of them have now come in for transcribed interviews over a month ago. Where are those witnesses, Mr. Chairman? Let's bring them in. Bring them in right here so that the American people can see for themselves what the entire basis of this subcommittee is. Now, you want to talk about censorship? You imagined in your opening statement a world where the FBI sends a list of books that should be pulled from their shelves. Luckily, we don't have to imagine that, sir. Are you aware that recent laws in Florida have resulted in the mass removal of books that are now banned in public schools?
I don't know about Florida. I do know that we have sworn testimony from FBI agent Elvis Chan that directly backs up the analogy I drew in my opening statement.
Okay, well, you should go look into this.
Expired.
You should go look into it because Florida right now is banning books, and you would agree that's a violation of the First Amendment.
Gentleman's
wouldn't you?
time's expired. Gentleman's time's expired.
Can the
And
witness
since-
answer the question? Would
No, because you were
agree?
over your time. And because you addressed the chair, I'll tell you, stay tuned, Mr. Goldman. There's much more to come in this committee. The gentlelady from Florida.
Mr. Sauer is recognized for his 5 minutes of testimony.
There's a motion on the floor to adjourn.
Motion to
And it is
adjourn.
not debatable,
It's not
Mr.
debatable.
If you don't know the rules of the committee, then talk to your parliamentarian.
Well, you weren't recognized for your motion.
Nor are you
Mr.
following the rules of the
Sauer is
committee. You can't
recognized
speak
for
out of
his
order.
5 minutes.
What are you doing? What are you doing? You're out of order.
Mr. Sauer, you
Listen
can
to your own
proceed.
words.
Mr. Chairman, Ranking Member Plaskett, members of the subcommittee. Imagine a world where White House officials email the New York Times editorial board when the paper runs a story criticizing the president. They abuse the paper in profane language and demand that it immediately pull the offending story from its website, while the White House publicly threatens devastating legal consequences if the paper doesn't comply, and it does. Imagine a world where the FBI every month sends all the major booksellers in the United States an encrypted list of the books that the FBI wants them to pull from their shelves that month and burn, and the booksellers comply by burning at least half of those books. Imagine a world where a federal national security agency teams up with a major research university to establish a mass surveillance program of ordinary Americans' political thoughts and opinions. They use swarms of analysts and cutting-edge technology to monitor hundreds of millions of domestic political communications in real time and covertly censor millions of them. These three scenarios do not come from a hypothetical dystopian future. The first two are very similar to what federal officials are doing with social media platforms now. And the third scenario is not hypothetical at all. That mass surveillance and mass censorship program started operating in 2020. Last July, the plaintiffs in Louisiana and Missouri against Biden received a limited discovery of communications about censorship between federal officials and social media platforms. What we obtained was astonishing, staggering, and horrifying. A veritable army of federal officials pressures, threatens, coerces, colludes with, demands, and deceives social media platforms to censor online speech. Our evidence shows White House officials badgering social media platforms in private to censor speech that contradicts the White House's preferred narratives, while the president publicly accuses them of, quote, killing people by not censoring enough of ordinary American speech. And the president's spokespeople raise the specter of crippling legal consequences if they don't comply. One major platform responds to White House demands by assuring them, we hear your call to do more, and it scrambles to carry out, quote, what the White House expects from us on misinformation going forward. Our evidence shows federal officials routinely flagging social media posts by ordinary Americans for censorship. It shows federal officials orchestrating elaborate plots of deception to dupe platforms into censoring disfavored speech. It shows federal officials engaging in seemingly endless meetings with the content moderation officers of major platforms to discuss disinformation and censorship. It shows federal officials serving as privileged fact checkers with effective authority to dictate what Americans can and cannot say on matters of immense public importance on social media. And it shows federal officials relentlessly pressuring social media platforms by threatening them with ruinous legal consequences if they do not cave to the federal demands for censorship. Truth is not the goal of this federal censorship enterprise. The censors have been proven wrong again and again, including on politically seismic issues. But each time the censors are proven wrong, the censorship has continued unabated, and it expands. And that is because now, as at every other time in human history, the goal of censorship is not to promote truth. It's to obtain, preserve, and expand political power. Censorship is not necessary to protect Americans' lives, security, or democracy. Systematically violating the most basic civil right of millions of Americans does not make Americans safer or healthier. Federal censorship is not democratic. It stifles the voices of ordinary Americans and places the channels of public debate under the command and control of elites. Censorship inflicts lasting harm on Americans by impeding the pursuit of truth in a free marketplace of ideas. The Supreme Court describes social media as the modern public square. For years, federal officials have been perpetrating a hostile takeover of that modern public square, and this hostile takeover has largely succeeded. Congress should take swift action to banish the federal censors and restore the freedom of speech to social media. I welcome the subcommittee's questions.
Thank you, Mr. Sauer. Mr. Seligman, you're recognized for 5 minutes.
Could have changed people's minds about the election.
And we know the polling demonstrates that now. People have said they would have changed their vote had they been made aware of the Hunter Biden laptop story. Isn't that correct?
I am not aware of that, but I'm not surprised.
Mr. Sauer, I want to turn to you. I want your reflection on this form of government censorship, specifically in the 2020 election, as a form of election interference, and what I believe is some of the most egregious political scandals that I will live through in my lifetime. Mr. Sauer, what are your reflections?
I strongly agree with your characterization of that form of censorship as election interference. The evidence in our case strongly supports that. It strongly supports, and actually we have judicial findings now, that the suppression of the Hunter Biden laptop story was done at the instigation of federal officials in the FBI at a very high level of that organization. It was an orchestrated campaign of deception that was anticipatory, it was planned in advance, and it was, I think, consummated with the testimony that I hadn't seen before that's been put up today from Ms. Demlow, characterizing how, at the very end, the FBI then clammed up at the last minute after spending months of seeding the record in these endless, ceaseless meetings with social media platforms about there's a hack and dump coming, it's going to involve Hunter Biden. Then when it actually came, they said, well, no comment. Our judge focused on that particular issue as kind of the coup de grace in this form of election interference.
Thank you. My time's expired.
Mr. Chairman,
Colleagues have truly provided a great service to this nation by exposing what we can rightfully describe as the surveillance industrial complex, the censorship industrial complex, the corruption industrial complex. Take your pick. Your testimony today is stunning, as is your written statement, and I encourage everyone to read the information that you have provided. The breadth and scope of this vast censorship complex is stunning and extends from the halls of Congress to the executive branch to the office of the President of the United States. As one of the last questioners today, I want to give you the opportunity to speak directly to the American public, and I'd like you to give us examples of just one or two takeaways that you believe are paramount as we continue our work and as we seek to hold this administration and these corrupt government hacks accountable for their blatant violation of the First Amendment to the United States Constitution.
I would emphasize maybe 2 or 3 points. First, federal censorship activities are not in retreat, they are expanding. Federal executive officials are expanding the topics on which they seek censorship. It's expanding to more and more agencies, and it's expanding to any social media platform they can reach to. So we are not in a situation where this is something that occurred in the past. We have overwhelming evidence that it's growing and growing and growing, and there's little indication that there will ever be any voluntary relinquishment of the power to dictate what ordinary Americans can say on social media. So it's a problem that is growing. It's a looming threat. A second point that I would make is that Censorship, as I said in my opening statement, both now and every other time when there's been censorship throughout human history, is not about truth. It is about political power. It's about obtaining power. It's about preserving power. And it's about expanding power. And the evidence of this, again, is overwhelming. You see it right there in the documents, some of which were just quoted. You see the White House saying, what we really want you to take down, Facebook, Twitter, and so forth, is borderline content. Borderline content that's described in the emails is often true. It's often true. It involves core political speech. We want you to take that down because that is what is most effectively undermining the narratives that we want to be out there on social media. That's an egregious violation of the First Amendment. It is viewpoint discrimination. I would also point out that many of the comments that have been made on the other side today have said we can't let there be misinformation on social media because a tiny minority of the 100 million people who might see it might take it and do something bad. You might call that the minority report approach to the First Amendment. It's absolute poppycock. It turns the First Amendment absolutely on its head. The promise of the First Amendment is that no official, high or petty, will be able to dictate what Americans do. Americans can make their own opinions. They are adults. They can read the evidence. They can form their own factual opinions and their own opinions. And that is the core and the heartland of the First Amendment, which we see radically perverted in the communications between the White House and virtually every other federal agency that's discussed in my extensive written testimony. I would also emphasize censorship does not make Americans safer. It does not make them healthier, and it does not protect our democracy. Censorship is what kills, not freedom. Freedom is what preserves our liberty. Freedom is what makes us safe and healthy as a society. So this notion that we've got to have censorship because it's going to be a threat to our democracy, what could be more anti-democratic than federal censorship dictating what ordinary Americans can say on social media? The First Amendment and social media radically democratize speech. The First Amendment is the most pro-democratic political statement in history, perhaps, because what it says is every ordinary citizen can decide for themselves without interference from federal officials as to what their opinion is. And we can participate in a free market ideas with freedom of expression, freedom of association to engage in that. And that's what we see under direct assault by a whole army of federal officials in this case. And finally, I would emphasize that this should not be a partisan issue. Censorship violates the First Amendment no matter what viewpoint federal officials are going after. Everyone in this chamber should oppose the sorts of pressure, collusion, deception, all the things you see in our evidence in this case. Federal officials should not be in the business of saying what Americans can and cannot say on social media. And those are the conclusions that I would offer the American people.
Well, and again, thank you for what you have just described. What an incredible summary and a statement of where we are in this country. We appreciate what you've done, what you've been willing to expose. And with that, I yield back.
Thank you. The gentlelady's expired. I'll yield to myself 5 minutes as we wrap this up today. We've heard a lot. Mr. Sauer, what you just said was extraordinary, and censorship of opposing viewpoints, and you've all seen it on display all day long. They've been doing exactly that. They've been trying to bully and defame our witnesses and try to cover up their opinions. They actually began the hearing with a motion to prevent them from testifying. You can't make this stuff up. It's on broad display for everybody. They did the same thing yesterday in the hearing with the IRS whistleblowers. You know why? Because the Democrats are panicked right now. They're panicked because it's impossible to cover up the inescapable conclusions of the last few weeks. Let me give you two of them. First, one, the hard evidence, Mr. Goldman and everybody else, now proves that the Biden family is hopelessly corrupt and has apparently engaged in a long pattern of extortion, bribery, influence peddling, and tax fraud, and staggering abuses of power. And number two, we're highlighting here today that we now know that a growing list of the most important executive branch agencies of the Biden administration are in on it. They've also been corrupted. They've been weaponized to help cover all this up, the first family's crimes. When we summarize all this stuff, it sounds like a premise of a dystopian novel or something, but it's actually happening right now on our watch. This is not conspiracy theories, this is evidence. Our hearing today is to put a spotlight on one more of these incredible avenues of unprecedented corruption and government cover-up. And here again, a federal court has just affirmed all that hard evidence. It proves that the White House, the Department of Justice, and the FBI, among other agencies, threatened and coerced the social media platforms to censor and suppress disfavored viewpoints and conservatives' social media posts online. I'm grateful we have with us today two individuals, Mr. Kennedy and Ms. Harris, who are directly impacted by that censorship, and the third, Mr. Sauer, who we're about to speak with, serving as lead counsel in the landmark lawsuit against the federal government on this issue. Let's talk facts. The American people are not aware of the magnitude of this case, Mr. Sauer, and its profound implications because most of the mainstream media is in on it too, and they're trying to bury the story. In brief, in May of last year, the attorneys general of my state, Louisiana, and the state of Missouri filed suit in U.S. District Court of the Western District of Louisiana. This blatant censorship. They went after the blatant censorship by the Biden White House in 9 of its federal agencies. 2 weeks ago on Independence Day, the district court issued a truly extraordinary 155-page court opinion, a ruling granting the plaintiff's request for preliminary injunction. Mr. Sauer, your lead counsel in that litigation. You referenced some in your opening statement, but let's do it again here because they don't seem to be paying attention. Can you give a summary again of some of the key components of that opinion and the basis for it? I know you mentioned there were 82 pages of detailed factual findings, right?
That is correct. 82 pages, 577 citations of the record evidence. That evidence is drawn from about 20,000 pages of the government's own communications with social media platforms and 6 full-length depositions of senior federal officials with firsthand knowledge of federal censorship practices.
It's absolutely staggering. And now they've tried to bury this and say, well, the Fifth Circuit entered a temporary administrative stay. They granted an expedited briefing and oral argument, however, for August 10th. What's the impact of that? Isn't that routine practice in the Fifth Circuit?
That's a direct quote from the recent Fifth Circuit decision, N. Ray Abbott, which is cited in my written testimony. It's legally incorrect, clearly legally incorrect to describe them as vacating the injunction, which has happened multiple times.
They either don't know the law or, I don't know, they're trying to obscure the facts. That's a theme around here. The White House and the fellow Democrats disputed almost none of the factual findings in the court. Isn't that right?
So far, we've had 2 emergency stay motions from the Department of Justice, one in the district court, one in the Court of Appeals. And what really struck me in reading those is they just don't dispute those 82 pages of factual findings. Almost none of them are directly disputed in what they've filed so far.
So at the very beginning of this lengthy opinion, the court explains the staggering scope of the government censorship uncovered here. At page 2, the court explains, quote, if the allegations made by the plaintiffs are true, the present case arguably involves the most massive attack on free speech in United States history. The court called it dystopian, Orwellian. How broad has this attack been? How many Americans have been censored, do you think?
There's judicial findings again and again in the opinion of millions of American voices silenced by these efforts.
And it had profound impacts. We know, we just saw the poll and the data that's been entered here, facts, not conjecture, that it probably changed the outcome of the election. The court noted that they suppressed, among other topics, the Hunter Biden laptop story. And the court noted, not you, not me, not Republicans, that millions of Americans were not exposed to that story. Had they been, we know they might have voted differently. We'll never be able to unwind history, but wow, I mean, the profound impacts. What are some of the other categories of speech that the government suppressed with its unconstitutional scheme?
Well, the court made findings on that. I just quote them: opposition to COVID-19 vaccines, opposition to COVID-19 masking and lockdowns, the lab leak theory of COVID-19, opposition to President Biden's policies, statements that the Hunter Biden laptop story was true, opposition to the policies of government officials in power. All were suppressed. And that's just some examples, many other examples in the court's findings and in the discovery in the case.
I so wish I weren't out of time. I yield back.
The gentleman yields back. The chair.
Witnesses at a hearing, is that what you're saying?
Mr. Sauer, you deposed Dr. Fauci.
Point of order. Mr. Chairman, could you clarify that statement because I find it incredibly hard to believe.
Point of order, that's not a point of order.
What basis in fact do you
Gentlelady
have
is not
for
saying a point of
making
order.
that assertion?
The chair now records
Are we
himself
just
for
here
his
to
5 minutes
allege
of-
wild
5 minutes of
allegations
questioning.
and have no factual
Mr. Sauer,
thing to pick it up?
the gentlewoman has not been recognized. Mr. Sauer, you deposed Dr. Fauci last fall. In that deposition, you asked him the question, you said, is it important for people to have access to both sides of the debate so they can assess what's good information and what's bad information? Remember that question you asked Dr. Fauci? And here was his response. He said, Dr. Fauci said, well, you know, it depends. If information is clearly inadequate and statistically not sound, there can be a danger in people who don't have the ability or the experience to understand. Mr. Sauer, do you forfeit your First Amendment rights if you can't tell good information from bad information? That's not how our First Amendment works, is it? You need to turn on your mic if you can, Mr. Sauer. Is the First Amendment only those for those people who have the ability or experience to understand?
No, it is for all Americans.
All Americans, all 330 million of us, is that right?
That's correct.
Not just for the special people, not just for the super smart people like Dr. Fauci, who worked 40 years in our government, highest paid guy. Not just for them, it's for all of us, right?
Absolutely right.
Even if maybe you don't know the difference sometimes between what's good or bad information, you still have your First Amendment liberties under our Constitution.
Both to hear and to speak, absolutely.
Exactly right. By the way, when you deposed Dr. Fauci, how many times did he happen to say he didn't know or couldn't remember?
He said, I do not recall or variations thereof 174 times, and adding in variations of I don't remember at least 212 times.
Wow. Smartest man on the planet couldn't remember 212 times?
He couldn't remember things, including things that he had told the national media, quote, I remember it very well. Then he would say 16 times, I don't recall details of that meeting.
Now you you were near the top of your class at Harvard Law School, Rhodes Scholar, is that right, Mr. Sauer?
I've submitted a biographical statement.
Yeah. Well, I looked at your biography. It's pretty impressive. Is that pretty high? You've done a lot of depositions. You've done a lot of legal work. You've deposed a lot of people. Is 212 times pretty high?
I've taken dozens of depositions. I've never seen anything like it, including in this case where other federal government witnesses frequently profess inability to recall.
So the guy who told us all these things, who's, the smartest man on the planet, he set a record. Highest you've ever seen and couldn't recall, didn't remember?
I've never seen anything like it.
Okay, page 4 of your testimony, you talk about the censorship enterprise. You give a bunch of facts and numbers here. You said Twitter disclosed that 84 government officials communicated with them, or as Mr. Seligman said, gave them suggestions. 84 federal officials gave Twitter suggestions on tweets and things to take down. 45 officials in the federal government told the same thing to Facebook. Is that right?
They discussed disinformation and censorship with those officials.
Yeah, a handful of federal agencies handed over 20,000 pages of documents in the communications they had with these big tech companies. Again, just suggestions, though, according to Mr. Seligman. 20 White House officials were involved in these suggestions to these social media platforms.
That's conservative. It's probably higher.
Yeah. FBI agent Elvis Chan testified the FBI alone sends encrypted lists to social media accounts, sometimes containing hundreds of accounts and URLs in each list to platforms for censorship 1 to 5 times per month. 500 times a month, 500 different email or websites, everything else they're sending to these social media platforms. The FBI, and Mr. Seligman says, don't worry, that's not a problem with the First Amendment. That's a suggestion.
Yes, over the course of years, that's been occurring.
The Election Integrity Partnership, a censorship consortium of academics, think tanks, federal and state government officials, social media platforms boast that it surveilled 859 million tweets, 21,897,364 tweets on tickets as misinformation. Is that right?
That's correct.
You learned this in your discovery in your lawsuit so far.
Correct, Your Honor.
And the Virality Project, a mass surveillance and censorship operation conducted by the EIP, has done over 6.7 million engagements on social media, 200 million. Now, let me just ask you this. Were most of those targets towards conservatives?
Virtually everything we've seen in evidence so far, or at least the vast majority of what we've seen in so far, is conservative, right-leaning speech.
But you would be just as outraged. I read your testimony. You'd be just as outraged if it was the other way around, right?
Absolutely.
Same here. Same here. Because the First Amendment, again, is not just for some people, not just for one political persuasion, not just for the so-called smart people like Dr. Fauci. It's for 330-some million Americans. That's how our Constitution works. Is that right, Mr. Sauer?
Every single American.
I thank the gentleman for his answers.
The Attorney General's complaint that you're litigating in federal court lacks a reasonable legal and factual basis. They didn't mention, as I understand it, just last week, the United States District Judge in that case denied the administration's motions to dismiss. Doesn't that denial mean the opposite of what Mr. Seligman testified? Turn on your mic. Is your mic on?
Our federal district judge came to the opposite conclusion.
Yeah. So, I mean, that conclusion is that the complaint plausibly alleges, it gives plausible factual allegations in support of a legally sufficient legal theory, that this censorship scheme, in fact, violates the First Amendment. Can you summarize some of the allegations of fact concerning coercion and threats that you tendered to the court to lead to that conclusion?
Yes, and I'd preface that by saying, in fact, there's more than one way you can violate the First Amendment. There's coercion, there's joint participation, there's conspiracy, there is deception, there is pervasive entwinement, and there is significant encouragement. So even if we hadn't alleged threats, it would in no way undermine our claim that there's a First Amendment violation. But there's overwhelming evidence of threats. And if I may, I can summarize some of those. So,
Give you a little bit of time on that, yeah.
Obviously, one of the things we've alleged is that the threats about antitrust liability and Section 230 repeal or replacement, those on one side are tied to demands for greater censorship. It's one thing for a federal official to say we should repeal or replace Section 230 immunity. It's quite otherwise for them to say, you'd better censor private American speech on social media or we will take that action against you.
Right.
It's the threat linked to the demand, which is what violates the First Amendment. And the case law is abundantly clear on this, and the evidence of that is overwhelming. But that's not all. We have all kinds of other threats. For example, in the Elvis Chan deposition, it was revealed that congressional staffers had been flying out to Silicon Valley to privately meet with the social media platforms since 2017, bringing proposed legislation with them to threaten them with adverse legal counsels if censorship didn't improve. And what Mr. Chan, the government's FBI agent, testified is that this was effective. They experienced the pressure. It made a huge difference. It's censored.
How many FBI agents did Twitter say interacted with Twitter?
I can't remember off the top of my head.
Numbers in the 80s, isn't it? 80-something?
Certainly the Foreign Influence Task Force includes about 78 to 80 agents, I believe, and then there's another 8 in San Francisco office alone that are involved in these activities, so many.
I know your written testimony contains hundreds of pages of these allegations, so it's interesting. Mr. Seligman, you referred to yourself as a professor. Now, you're a fellow at the Constitutional Law Center at Stanford Law School, isn't that right?
That is correct.
And you're not on the faculty at Stanford Law School?
That's right, and I didn't claim otherwise.
Okay. You graduated from law school in 2011. Your LinkedIn resume suggests you haven't had any job longer than about 3.5 years since then. I looked on Lexis. I couldn't find any case in which you've served as counsel of record in which you finally prevailed. Can you name one?
I've worked on legal teams that have prevailed at every level of the federal judiciary, including the Supreme Court.
Can you name a
of the United
case?
States. Yeah, sure. So Tyson v. Buafekio, which is a case at the Supreme Court.
Tyson versus what?
Buafekio was a case. It was a case about Rule 23 class certification.
Okay.
We prevailed.
Okay. What reason is it? So you're not a professor. Do you claim expertise in the First Amendment? Do you claim to be a First Amendment expert?
I am an expert in constitutional law, including the First Amendment. Yes.
Interestingly enough, on your website, on the Stanford website, it says you're an expert in election law, but you also have broad research interest in constitutional law. It doesn't even mention the First Amendment.
As many legal scholars do, I have a diverse set of interests.
Mr. Sauer, wouldn't it be squarely in conflict with the First Amendment to censor Mr. Seligman's opinion just because it conflicts with the official narrative as represented by the district court judge's opinion?
Absolutely. The First Amendment protects everybody.
Can you take in the last few seconds I've got and talk briefly about how the Election Integrity Project and the Virality Project have moved to censoring whole narratives?
Yes, there's, I see the time is almost up, but there is a concerted effort that we see in the evidence to censor narrative at a narrative level, where a narrative can contain hundreds of thousands of social media posts, and that is operated out of Stanford University.
Gentleman's time's expired. Gentleman from Texas, Mr. Allred, recognized for 5 minutes.
Thank you, Mr. Chairman. Mr. Sauer, when you came to the Capitol today, did you go through security? Yes or no?
Yes.
Did you interact?
Gentlewoman's time has expired. Yields back. The chair now recognizes the gentleman from Florida, Mr. Gates.
White House staffers are some of the most powerful people on the planet Earth. Oftentimes, they get the dispositive opinion on appointments to different positions within the federal government. They influence statements of administrative policy. They initiate regulatory reform. They often have a significant voice on legislation that is considered and approved. And so, Mr. Sauer, I want to understand how many of these intensely powerful people who work in the Biden White House were involved in this effort that you've been investigating regarding the desire to shape discussions on social media.
At least 20 and very likely more.
And was there a ringleader of this group, someone who had pervasive and repeated efforts to try to coerce social media companies to shape the truth according to the Biden White House?
Deputy Assistant to the President Rob Flaherty and also Andy Slavitt.
Who is Rob Flaherty?
He is the, I believe, the digital coordinator for the White House. His level is Deputy Assistant to the President.
And what behaviors of Mr. Flaherty did you observe that you found troubling?
We've seen many, many pages of emails between Mr. Flaherty and social media platforms where he relentlessly badgers them to increase the censorship of ordinary Americans' free speech on social media, and he gets results. You see the platforms agreeing to censor things that are truthful, that do not violate their policies at the behest and at the pressure of the White House.
Can you give an example of that?
One great example of this is the Tucker Carlson video that was going viral in April of 2021, where Mr. Flaherty and other White House officials were emailing Facebook privately demanding that it be censored. Facebook responded, "This does not violate our policies. It has not been fact-checked, but nevertheless, we are substantially deboosting it and limiting its distribution on our platforms, even though we haven't identified anything false in it. And even though it does not, they had a positive determination that it does not violate their policies."
And did you assess that Facebook took that action as a direct consequence of the badgering coming from Mr. Flaherty in the Biden White House?
That is a compelling inference from the email traffic back and forth that we obtained in discovery.
And did Mr. Flaherty ever request any reports from social media companies on specific censorship issues?
Very frequently. In fact, he was demanding that again and again. His steady drumbeat was what he called borderline content, that the email traffic makes clear. Borderline is what they call often true content, things like personal anecdotes, opposition to vaccination expressed in terms of political opposition, things of that nature. That is what he wanted to target, and he was frequently asking for reports back. They were sending in bi-weekly crowd tangle reports to the White House. They did that through the close of our discovery period last August in 2022. So there was an overwhelming effort to get them to check their homework, if you will, to get them to report back on how much censorship are you doing and is it going to meet our standards as the White House?
An overwhelming effort, badgering social media companies, demanding reports from those social media companies directly to someone in the White House. And as my colleagues on the other side of the aisle remind us, not all speech is protected. Some speech is illegal. Did you see Mr. Flaherty constrain his concern to unlawful speech, or did you often see this badgering and this demand for reports from entirely lawful speech?
Virtually everything. I can't remember a single instance of them going after unlawful speech.
Almost all of it was after lawful speech?
Virtually everything that I can recall here was lawful First Amendment protected speech that was being targeted.
We heard from the witness that the Democrats brought today that these were but suggestions, that of course the government should be able to make suggestions to social media companies. What would be your response to that testimony?
The characterization of them as suggestions is contradicted by overwhelming evidence. Calling Flaherty, for example, Mr. Flaherty's communication suggestions is akin to saying that the earth is flat or the moon is made of green cheese.
Well, and of course, if someone shared those viewpoints, that would be lawful speech, wouldn't it?
You'd be allowed to say that on social media, and based on the
Not if Mr. Flaherty were in charge.
That is the difference. And in fact, what happened was you had a de facto suppression of many, many views, including truthful views, political organization, at the behest of White House officials and other federal officials.
And I would suggest, Mr. Chairman, that when you have these intensely powerful people with the ability to control so many things, even a suggestion is coercive and problematic and worthy of the committee's review. I yield back.
Thank the gentleman for his 5 minutes. The gentleman yield.
Administratively stayed. So it hasn't been vacated or dismissed like Mrs. Sanchez
It's
said.
stayed, which means it cannot be implemented right now.
Okay, because I didn't want us to censor your disinformation that you stated as a factual assertion earlier. So
I did misspeak, and I apologize.
Thank you for clarifying that for us. And to talk about more evidence about, I think it's interesting. There's a lot in this opinion, and I have limited time, but I think illustrating some of the actions that the Biden administration took to censor speech is very important. I'm going to read specifically from the opinion. Explicit threats are an obvious form of coercion, but not all coercion needs be explicit. I'm on page 97 of the opinion. The following illustrative specific actions by defendants are examples of coercion exercised by the White House defendants. A, cannot stress the degree to which this needs to be resolved immediately. Please remove this count immediately. Sounds like a directive from the White House to me to social media companies. Accuse Facebook of causing political violence by failing to censor false COVID-19 claims. F, this is exactly why I want to know what reduction actually looks like. If reduction means pumping our most vaccine-hesitant audience with Tucker Carlson saying it does not work, then I'm not sure it's reduction, implying that they're reducing the information on that. Questioning how the Tucker Carlson video had been demoted since there were 40,000 shares. Wanting to know why Alex Berenson had not been kicked off Twitter because Berenson was the epicenter of disinformation and radiated outward to the persuadable public. And I'm just skipping through here. I'm not even going through all these. Flatteringly stated, not to sound like a broken record, but how much content is being demoted and how effective are you at mitigating reach and how quickly? Flattery told Facebook, are you guys effing serious? I want an answer on what happened here and I want it today. Sounds like a pretty explicit threat to me. Letter M, White House Press Secretary Psaki stated, and I quote, we are in regular touch with these social media platforms, and those engagements typically happen through members of our senior staff, but also members of our COVID-19 team. We're flagging problematic posts for Facebook that spread disinformation. Psaki also stated, one of the White House asks of social media companies was to create a robust enforcement strategy. Oh, Psaki stated on the February 1st, 2022 White House press conference that the White House wanted every social media platform to do more to call out misinformation and disinformation and to uplift accurate information. Another one, hey folks, wanted to flag the below tweet and I'm wondering if we can get moving on the process of having it removed ASAP. Sounds like a pretty explicit demand from the White House to me. Again, quoting the opinion. These actions are just a few examples of the unrelenting pressure the defendants exerted against social media companies. This court finds the above examples demonstrate that plaintiffs can likely prove the White House defendants engaged in coercion to induce social media companies to suppress free speech. Mr. Sauer, in the limited time that I have, can you just comment further on, these are just some of the highlights that are in the opinion, and illustrate to us all of the evidence of the White House censoring the American public and working with social media companies to accomplish that?
It's very telling that the judicial findings are quite specific on the specific threats. So there's several ways you can violate the First Amendment if you're a government official. One is coercion, one is significant encouragement, one is joint participation where you've insinuated yourselves into private decision-making. The court found all of those present here. And with respect to those White House communications, there's a series of specific judicial findings that these statements were threatening. They were threatening adverse legal consequences. There's multiple findings, for example, that White House spokesperson Psaki's public statements explicitly linked the threat of adverse legal consequences to the White House's demands for censorship, which we didn't know at the time, but now know were being very aggressively peppered on the social media platforms while she was making those public statements. So you have public statements from the White House. Also, White House Communications Director Bedingfield, there's a very specific judicial finding on that. Threatening adverse legal consequences in public if there's not greater censorship, and in private, you've got Rob Flaherty, Andy Slavitt, other White House officials saying, take this down, do more to take down borderline content.
Time of the gentleman has expired.
Mr. Chairman, I have unanimous consent request.
Gentleman from Louisiana.
There's a lot of talk about this preliminary injunction, so I'd like to enter into the record a 155-page court opinion.
Please rise. Justice of the Appellate Division, Supreme Court, first of all. Hear, hear. All persons having business with the Appellate Division, join here. defendants, and you shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. At this noon calendar, we're going to hear the argument of the State of New York versus Trump. When you request your time, please understand that we have the record, we have your briefs, all of the briefs, and we're familiar with the facts of the case, so ask for the time that you need to make your most important argument. I'm going to ask now for the appellant to rise and tell me the amount of time that you would like for argument. You can do either way.
The court previously granted my colleague John Sauer pro hoc admission for the brief, and this morning or this afternoon at this point, we'd like to ask the court's permission for the argument.
Your request motion is granted. The time?
Time, Your Honor, we'd ask for 15 minutes, 10 minutes in opening and 5 minutes in rebuttal, if that's
Okay, 10 and 5.
Brian Isaac, I represent the non-party appellant. I know you usually only have 15. Could I just get 3 and 2 on this? Reduce my time to 3 and 2, if that's okay.
Thank you very much. Won't argue with that. 3 and 2, 10 and 5, yes? So we have a limit of 15 minutes. If you want to, do you want to split that so that you can have rebuttal time?
I mean, we'll just take a full 15 minutes. I guess I wasn't quite sure how to divide it for the non-party.
Okay. All right. And you represent the state. The state, right. So you...
Maybe one way to do it would be 15 for the main appeal and 2 for the other.
I would think that you should... So you don't want any rebuttal on either one? So why don't you do 15 and 2? I'm sorry, 13 and 2. Okay. If you would, yes.
Thank you, Your Honor, and may it please the court, John Sauer on behalf of the appellants. This case involves a clear-cut violation of the statute of limitations and the law of the case doctrine. Last year in Trump 1 at 217 AD 3rd, page 611, this court held that no liability could be assigned for transactions that were completed prior to February of 2016 or 2014.
Mr. Sauer, that's premised on the fact that the statements of financial conditions cannot give rise on their own to a new violation of 6312, right?
That is correct. That's
Then why didn't we say that in the earlier decision on the motion to dismiss when we were reviewing the motion to dismiss?
I think that's what the phrase, the continuing wrong doctrine does not apply to delay or extend limitations period means, because that is the continuing wrong doctrine. To say that like a 2017 or 2018 statement, is a new discrete wrong that's distinct from the original transaction that closed way back in 2012, that just is the continuing wrong doctrine.
You don't think it applies to Ivanka Trump's arguments on that appeal or to the Attorney General's now discarded theory that there was somehow a large amorphous fraud that somehow told the statute of limitations all the way back to 2011? Isn't that statement applicable to either of those two arguments made on the motion to dismiss appeal?
Your Honor, if I understand the question, the dismissal of Ms. Trump strongly supports our interpretation of the prior opinion because, of course, the allegations with her in the complaint are virtually identical to the allegations against the other individual appellants. So if you look at the complaint, you see virtually identical claims and theories as to those two. And once this court held she's not covered by the tolling agreement, she was completely dismissed from the case. The same should apply to anyone who's not covered by the tolling agreement here. And I would emphasize further, though, that there's really two errors here. Because even if the continuing wrong doctrine did apply, it still doesn't allow the trial court to do what it did, which is to go way back in time to 2011 and 2012 and assign liability and major consequences, huge financial consequences, based on an analysis that never looked at a 2017 or 2015 statement and said what liability flows from just that statement that comes much later in the course of conduct.
And loans which closed long ago.
Exactly right, Your Honor. And again, this court addressed this squarely in the Henry decision, which is cited in Trump 1, the CW Capital decision, which is cited in Trump 1. What Henry says is, even if you apply the doctrine, it only applies to allow liability for statements within the limitations period. But that's not what the trial court did here. That's not what the Attorney General's office contended. They said, oh, we're going to apply the continuing wrong doctrine. That contradicts Trump 1, so that was the first error. But then the second error is, once we've done that, we're going to pretend there's no statute of limitations at all. And we're going to go all the way back in time and assign crippling financial liability for transactions that concluded again in 2011 and 2012. So there's a direct contradiction, a direct disregard of the prior, this court's prior opinion. It becomes really clear, I think, when you look at, for example, there's a citation of the Yin-Shing Lung decision by the trial court. And the trial court says this shows this is a continuous series of wrongs, each of which gives rise to its own liability, when there was an opinion from this court 3 months earlier saying the continuing wrong doctrine does not apply. That makes it very clear.
But again, shouldn't we have said, or wouldn't we have said, these statements of financial condition that fall within the limitations period don't give rise to a 6312 claim? Shouldn't we have just said that? Would saved everyone a lot of time.
I think that's clearly what the continuing wrong doctrine means if you apply it. And again, the dismissal of Ms. Trump strongly supports that. But in any event, Your Honor, even if the court doesn't agree with that, there's still a massive violation of the continuing of the statute of limitations, because again, under Henry and versus Bank of America and under the CW Capital decision, the most the trial court could have done is looked at the 2017 statements and said, what liability can I assess to that? Can I oppose to that? And that is not at all what happened in the trial court. There was just a complete disregard of statute of limitations and an analysis that again and again goes all the way back to 2012.
Even if we agree with you on the statute of limitations point, that would not result in the complaint in its entirety being dismissed. There would still be several transactions that would be not time barred or timely. So what is your response to, or what is your strongest argument as to for dismissal of those claims, those exited non-time barred claims?
Right, there would be 2 of the 10 that were charged in the complaint that we've identified that would only apply to those covered by the tolling agreement. Like Ms. Trump, if you're not covered by the tolling agreement, it's all gone, essentially. But in answer to your Honor's question, we argue that there was a complete failure of proof on the critical element of capacity or tendency to deceive, which is an element required of any 6312.
Well, if I can stop you there, are you talking about a failure of proof at trial?
Absolutely, Your Honor, as well as in summary judgment. So we raised this.
Okay, but cause of action number 1, which is the fraud-based claim under 6312, liability on that was not tried, right? That was determined at summary judgment.
That is correct, Your Honor.
Okay,
And so we challenge it as to both, yes.
I don't believe we can look at the trial record to answer any questions about the sufficiency of cause of action number 1 based on fraud. Don't we have to confine our review to the summary judgment motion record?
Well, to the extent that the trial court in the final decision was repeatedly referring to reinforce its prior holding in summary judgment, yes. Now, our position, of course, is that the failure of proof is even more defined, even more clear when you look at the summary judgment record. For example, just a couple citations to put this in context. Summary judgment record, page 13965 of the record, is a Deutsche Bank witness, uncontradicted, saying if his net worth had been as low as $1 billion, for example, he would have gotten exactly the same deal. It would have been exactly the same transaction. That's uncontradicted. It's reinforced by the trial testimony.
But could the trial court have credited Mr. Hayes' statement? He's also a Deutsche Bank employee, correct? And he said that if the facts were, if the SFCs were incorrect, then they didn't properly assess the risk on these loans. Mr. Hayes said that. You would say that in your brief, I believe.
He made a much more generic, if you look at that particular citation, he made a much more generic content that we want to make sure we're being compensated for our risk. What is not disputed is the testimony that if the net worth had been as low as $1 billion, and again, this is the testimony of Williams, if the net worth had been as low as $1 billion, the deal would have been exactly the same. And so it's astonishing if you look at, for example, page 1882 of the record, which is their schematic that they cite 9 times in their brief, they concede that President Trump's net worth ranged between, on their view, $3 billion and $4.7 billion throughout this entire period, which is miles above.
If you're talking about summary judgment, isn't it basic that you don't make credibility determinations on the motion?
Absolutely correct, Your Honor, and we have a repeated violation of that, as we point out in our briefing. For example, there's sort of kind of astonishing credibility determinations to disregard unrebutted in the summary judgment record expert testimony. So if you look at 17.916, the summary judgment affidavits of Bartoff, where he explains how all these representations, virtually everything they challenge, is consistent with generally applicable accounting standards. They're GAAP compliant statements. That's unrebutted in the summary judgment record. It goes beyond merely being disputed and you couldn't decide it by a credibility determination. There's really nothing to the contrary. And again, these errors are all reinforced at trial, so we are challenging both of those. And if you look particularly at Professor Bartoff's testimony, you have this clear explanation that all the things that they say are misleading are things that are specifically approved in ASC 274.
Creating an issue of fact, correct?
Exactly right, Your Honor. That's exactly right, Your Honor. That's at the very least, that's a disputed issue of fact. It isn't just Professor Bartoff. There's a whole series. There's Professor Flemons. There's a whole series of experts. When you get to, yes, Your Honor.
Well, you finished that, but then I have a question for you about the scope of the statute.
Go right ahead, Your Honor.
Okay, yeah. No, so just looking at the language of the statute, it says that it's enacted to promote the honesty and integrity in commercial marketplace in New York by stopping fraud and illegal business. So to accomplish this, the statute authorizes the Attorney General that whenever a person shall engage in repeated fraudulent, I know that you're challenging that, or illegal acts, that they can bring such an action. So why isn't the language of the statute here referring to the repeated and fraudulent illegal acts or persistent fraud or legality? Why doesn't that define the scope of the statute? Why do we need to go to harm or threat of harm?
Yes, Your Honor. So the standard is that, as this court held, for example, in General Electric, is there has to be a capacity or tendency to deceive or atmosphere conducive to fraud. And what we've pointed out is that you have a situation where there were no victims, no complaints, no evidence of causation, materiality, or reliance. There were sophisticated counterparties who, the understanding of the relevant marketplace, as this court said in the Nordbank decision, understood that they would be doing their due diligence. They did do their own due diligence. The uncontradicted testimony in the summary judgment record is everything we did was independent. We didn't rely on the numbers. That's the Williams testimony in the summary judgment record. All that is evidence, for example, the Domino's Pizza decision that we've cited powerfully makes this point, where all of that is lacking. All that is powerful evidence that there was no capacity or tendency to deceive, which ties into our point that every single one of these transactions would have looked exactly the same.
I'm sorry, counsel. What about deterrence? In other words, the AG would have the argument that maybe these deals went down fine as far as all the parties were concerned in these deals, but in the future, some deal might not go down well, and someone would be harmed by that. And so we need to deter parties from putting in, fallacious statements of financial whatever. Go ahead.
May I respond?
Yes.
Red light. Just to answer that question, the deterrence interest goes entirely the opposite direction, where we have a situation where the Supreme Court disregarded unrebutted expert testimony that these are GAAP compliant, these are consistent with accounting standards, which don't require perfection.
No, but the Attorney General points out that whether or not they're consistent with GAAP principles, it's the factual inaccuracies that are important. So in other words, you might be following GAAP principles, but if your data is terrible, then you're creating a fallacious statement.
With respect to that, that disregards or at least misinterprets our expert testimony, which look at what they say is factual data that's misinterpreted. For example, appraisals. Essentially the Supreme Court said if you got an appraisal in your file, you got to rely on that. You can't rely on your own independent judgment. They say that's a factual inaccuracy. GAAP says the opposite. At least that's the unrebutted testimony in the summary judgment record. And I would direct the court to page 17916, the beginning of Professor Bartoff's summary of opinions on that.
I want to turn your attention to a different subject because your red light is on. I'm trying to figure out about the valuation of Mar-a-Lago. I noticed that your expert, Mr. Moans, valued it at over $1 billion. He also said that if it was in the hands of a new owner, club memberships, 500 club memberships could be sold, generating $250 million. And and generates revenue of over $50 million a year in 2022 and 2023. And Supreme Court values it at $18 to $27 million because of restrictions. Do you have anything to say about those restrictions taking it down in value to such an extent?
Those are, I'd say two things in response to that. First, the Shubin affidavit directly addresses that. That was improperly kind of disregarded.
He says there are no restrictions on it. He says there aren't, Shubin says there are no restrictions.
He says you have to interpret, he says the trial court looks at one document in isolation, the deed of conservation. Mr. Shubin says you got to look at all 5 documents, including the historical practice there, to understand what the actual policy is. And for example, they say he couldn't value it as a private residence, but he's been using it as a private residence since 1995, continuously to this day. But the more fundamental point is that valuation, where he relied on a tax assessment, illustrates the hazards to the marketplace as a whole here from having the Supreme Court cite things like Chico Marx in footnote 9 of the summary judgment position, the I know it when I see it standard from obscenity law from Justice Potter Stewart to decide what's a misrepresentation in these statements. When you have expert testimony unrebutted that says these are gap consistent, if we have a system where you can issue perfectly accounting, clear and basically statements that comply with gap, and you're held, well, we have another standard, I know it when I see it, that's good, that's bad. People can't do business in real estate. So,
Thank you.
thank you, Your Honor.
Oh, I'm sorry, there's another question.
Sir, are you asking us to draw any bright line rules as to the contour of the AG's authority under 6312, or are you asking us to scrutinize the evidence that was adduced either at summary judgment with respect to claim number 1 and then at trial with respect to 2 through 7?
The latter, Your Honor. So our argument is on the unique facts of this case, you cannot come to the conclusion that the plain language of the statute was violated. And we argue, obviously, that it raises constitutional questions as well under Grasso and under the excessive fines clause and so forth. We make all those interpretive arguments. But the fundamental point is, if you look at these unique facts on this case, the statute just doesn't cover it. And if it does, it has no limitation.
It's your position that under the facts of this case, 6312 didn't support the taking the action that was taken.
That's exactly right, Your Honor. Thank you, Your Honor.
Good afternoon, Your Honors. Brian Isaac, as you know, I represent the non-party appellant attorneys. My argument is not as sexy as the other arguments, but I think it's a hugely important argument to me as an appellate litigator. I think that the New York State judicial system is the best in the world. I don't think it's better arithmetically, I think it's better geometrically. And I think most of the credit goes to you, but some of it goes to us also. You can't do your job in an exemplary fashion unless we do our job competently. And every single lawyer who practices in New York knows it's not what you get at the trial level, it's what you keep in the appellate division. It is an absolutely horrible idea, in my judgment, to sanction attorneys for making motions for summary judgment in cases where they have to do it to preserve the issue, not only here, Your Honors.
You don't want to take a chance on the appellate court saying, oh, they didn't preserve the issue.
Judge, it's not only here. This is a Trump case. Like him, don't like him, it doesn't matter. This case is a case that definitionally could go to the Court of Appeals. Look at 522B41, look at Cialina against Erie Preserve, look at the number of amicus briefs that you had. I couldn't even read them. You have to preserve these issues. And there's one fact that I want to bring to your attention. I know you know it, but we probably should have brought it out in the brief more. You have interest of justice jurisdiction. You can, if you want, decide unpreserved issues. You almost never do it if you don't believe me. Just run my name. Just put Brian J. Isaac, in quotes, within 8, put preserved, unpreserved, not preserved. See how good I've been. I'm not 0 for 5. I'm not 0 for 10. I'm 0 for 3 decades on that. But this court can do it. The Court of Appeals can't. They do not have any interest of justice jurisdiction. They are not allowed to decide mixed questions of law and fact. They can't decide damage issues. They can't decide that a case is against the credible weight of the evidence. How can a competent attorney, and these people are competent attorneys, risk a $440 million malpractice claim by not raising an argument that's a tenable argument? And I'm not going to go over my time because I don't, but I wanted to say something to you. The Attorney General and the trial judge excoriated the lawyers for making a motion for summary judgment on disgorgement at the summary judgment level. One of the cases they rely on is People against Ernst & Young, which you know. Can I read to you what you said? This isn't Brian Isaac, it's not Michael Ross who wrote the brief for me. This is the Appellate Division First Department. I'm reading it verbatim. Quote, therefore, while the Attorney General does not allege direct injury to the public or consumers as a result of defendants' alleged collusion with Lehman Brothers in committing fraud, the equitable remedy of disgorgement is available in this action. Here's the key point. And it was premature to categorically preclude it at the pleading stage. That's verbatim. That is exactly what these lawyers did. And to be sanctioned for it is just wrong and threatens the integrity of what I think is the greatest juridical system we've seen. You shouldn't allow it.
Thank you. Counsel. So you have 10 minutes on this first. You have 10 minutes on this.
Well, I don't know if it's easier, Your Honor. Since we're the appellees, I'm happy to just take the full 15 minutes as the appellee, and that,
okay.
I think that maybe simplifies things. May it please the Court, Judith Vale for the New York Attorney General's Office. All of the defendants repeatedly violated...
Ms. Vale, can you identify any previous case in which the Attorney General sued under Executive Law 6312 to upset a private business transaction that was between equally sophisticated partners where the supposed victim had the ability and legal obligation to discover the allegedly misrepresented matters by conducting its own due diligence, where the supposed wrongdoer advised the supposed victim through written disclaimers to conduct its own due diligence and to draw its own conclusions, where the alleged misrepresentation almost entirely concerned inherently subjective valuations of properties and businesses.
Yes.
And where the victim never complained about any fraud in the transactional losses from it. Because I've gone through the cases which you've cited, and all of them always involved the consumer protection aspect. It involved protection of the market.
Well, several responses.
And I want to add to his question, and little to no impact on the public marketplace.
Well, maybe I'll take that first, Your Honor, and work backwards. There was absolutely a public impact and a public interest here. There are at least 4 different public harms from the kind of misconduct here. First of all, when deceptively hidden risks are injected into the market, that does hurt the counterparties, and there was harm to the counterparties here, but it also harms other market participants and the market as a whole because they are not understanding the risks, they are not pricing them in properly, and they are not prepared for what might happen if the true risks come to pass. Also, as the legislature made clear in passing 6312, it was concerned with harms to the honest business people who don't do the misconduct and therefore don't get the kind of benefit that they got here.
I suppose you're referring to the fact that Trump received a lower interest rate than he might otherwise have received. But haven't you yourself conceded that the assets were sufficient to get the lower interest rate of the private wealth management direction?
Absolutely not, Your Honor. That is not conceded one bit, and the evidence is to the contrary. If you look at what the Deutsche Bank witnesses testified to, Haig said that the financial strength of the guarantor affects the pricing in terms of the loan. That's in the record at 28167 to 68, and it affects whether the private wealth management group would be allowed to do this deal at all. That's at 28150 of the record. And you have to remember something. As the net worth as the statements were coming in, the Deutsche Bank was doing a stress test. So if without the fraud, the net worth and liquidity would have started much lower. And then you do the stress test, and it takes it down much lower. It does not look like such a strong financial guarantee anymore. It does not look like an ironclad guarantee anymore. And it was absolutely a fair inference that Deutsche Bank would not have given these loans without the financial strength being inflated. That was also evident from Haig and McCarty testifying about the incredible
Doesn't Mr.
collateral.
Doesn't Mr. Haig testify that there were 14 factors and this was the least important factor?
Well, certainly there are multiple factors that go into the risk assessment, but both for materiality and for disgorgement, the issue is not whether there's only one factor. There's often a lot of factors that are being considered. For materiality, it's whether it's important to the overall total mix of information, and this was absolutely critical to the overall mix of information, not only because they were looking specifically at what the net worth was in order to decide the terms of the loan, in order to figure out whether they would take on this risk, but also the financial statements were coming in each year, and they were important, critical to the loans each year, because Deutsche Bank was reassessing the risk every single year, and it was using—
I'm sorry, but what's being described sounds an awful lot like a potential commercial dispute between private actors.
Well, to go back to the first question about whether there's other examples of this, there are other examples of this. In the First American case, the Attorney General brought a 6312 case where the transaction at issue was between a very big bank, Wells Fargo, and a professional appraisal firm.
But it wasn't the concern there that the public would ultimately be negatively impacted and affected by what those corporate actors were doing.
And that concern is here as well, because when you have hidden risks getting injected into the market, that hurts the market and honest participants in the market. And the legislature also decided, contrary to what defendants think, that making sure that business in New York stays honest is the way to attract and keep business
So to that
in New York.
point, the Executive Law 6312, I just want to read a section of it. Well, not exactly, but was enacted to promote and protect honesty and integrity. It's the same question I asked the other side. In commercial marketplaces in New York, by stopping fraudulent and illegal businesses. To accomplish this purpose, the statute authorizes the Attorney General to bring civil enforcement proceedings on behalf of the people whenever any person shall engage in repeated fraudulent or illegal acts or otherwise demonstrate persistent fraud or illegality in the carrying on, conducting, or transacting of business. I don't read harm or threat of harm in that, but the other side is saying that that is to be read into the statute. Are there any cases where the language harm or threat to harm limits the scope of the Attorney General?
No, Your Honor, not as to liability, and not in cases like this where what the Attorney General is seeking is injunctive relief and disgorgement. Greenberg from the New York Court of Appeals and Ernst & Young from this court make clear that reliance by a counterparty and actual harm to a counterparty are not required for liability for any of the claims here. And remember to think about the illegality claims as well, because it's not just fraud.
Could you just let her finish the question?
So for the illegality claims, you look to the underlying penal law provisions. And for something like issuing false financial statements, there's no requirement for reliance. There's intent and there's materiality, which was proved at trial. But if someone issues a false financial statement to their counterparty, the counterparty gets it and is not fooled, picks up the phone and calls the enforcement authorities, the crime has still been committed, even though the counterparty didn't rely on it at all.
So you're pointing to Ernst & Young, you're pointing to First American. Ernst & Young, you're dealing with the collapse of Lehman Brothers. First American, you're dealing with an action brought against an appraiser who overvalued properties at the behest of a lender perpetrating a scheme to induce unsophisticated consumers into taking out home loans that they could not afford. It hardly seems that justifies bringing an action to protect Deutsche Bank against President Trump, which is what you have here. I mean, you've got two really sophisticated parties in which no one lost any money, and that was the point of my initial question. Every case that you cite involved where there was damage to consumers, damage to the marketplace. You've got a scheme to get unsophisticated consumers to take out home loans. You got a collapse of Lehman Brothers. You don't have anything like that here.
Well, first of all, Your Honor, the statute doesn't require that whatsoever for liability. And the statute is written broadly because the legislature wants the Attorney General to go in and stop fraud and illegality.
Also, an example of what you're talking about, I think, is People versus Allen, isn't it? There it was just a dispute among partners.
Yes,
it didn't affect the public, at all. But I think you hear underneath all these questions, the question of mission creep. Has 6312 morphed into something that it was not meant to do? And that's something you must address, because there has to be some limitation on what the Attorney General can do in interfering in these private transactions, as Justice Friedman said, where people don't claim harm. So what is the limiting principle?
Well, I'll say two things, Your Honor. Well, first of all, the limiting principle are what's in the law. So the illegality claims require intent. They require materiality.
Let's talk
most
about the
of them.
but talk about the standalone.
Just for the 6312 fraud. Well, this court has defined that rather broadly, but there are still limits. It is not falsity in the wind, first of all. It is not falsity that you whisper to someone on the couch. It has to be related and relevant to the business at hand, and it does have to have a capacity or tendency to deceive. It has to have a capacity or tendency to deceive. And I will stress, Your Honor, that this does have harm to the public and to the markets. And I think what Your Honor is saying is that in some of the other cases, the ripple effects happen to happen. It went so far that the ripple effects from fraud went on to hurt the market. But what the legislature wanted was 6312, just like for the Martin Act. And the Court of Appeals talks about this in assured guarantee.
To be prophylactic, is that what you're about to say, counsel?
Yes, look at the assured guarantee case from the Court of Appeals. It talks about how a big point of these statutes, not the only point, but a big point is for the Attorney General to go in quickly to stop the fraud and illegality before it gets to the point that counterparties are harmed or it has those kinds of ripple effects in the market. I do want to, though, push back on the idea that Deutsche Bank never complained and wasn't harmed at all. Deutsche Bank did complain. When they first found out about the alleged misstatements and omissions, they raised serious concerns with defendants, said that misstatements in the financial statements would be an event of default. They asked for more information, and when they didn't get more information, they exited the entire relationship with the Trumps. That shows that they cared about the financial statements being truthful and accurate.
What year was that in? What year was that in?
It was right when they first heard about the allegations, so I believe it was 2020, Your Honor, although I'd have to check the precise year on that. And Mazars as well, when Mazars found out about the alleged misstatements and omissions, they also sent a letter saying these financial statements should not be relied upon anymore. So it is not true that the counterparties didn't care or never complained, even though that's not required for 6312.
Also, I'm sorry.
Go ahead.
I'm moving off topic, so if you have a question on this, go ahead.
Maybe a better topic than mine. Back to Justice Moulton's point about line drawing, because I do think that is very important in this case. You know the history of this statute. It's passed under then AG Javits, and then was really amplified by AG Lefkowitz over the years. And when I went back and read the bill jackets, the common thread was always we need greater power. The AG needs greater powers as the people's lawyer to protect consumers, civil rights, and the environment. And so again, with that sort of historical backdrop to this law, how do we draw a line or at least put up some guardrails to know when the AG is operating well within her admittedly broad sphere of 6312, and when she is going into an area that wasn't intended for her jurisdiction?
Sure, Your Honor. Well, I will say, although there was certainly concern about consumers, especially at the outset of 6312, in some of the legislative history, there were multiple bills being passed, and some of them were more specifically consumer protection statutes, which I think explains some of the focus. And the legislature wrote this statute. It doesn't say consumers in it. It wasn't focused. I mean, of course, we want to protect consumers. I'm not saying otherwise.
It does start off with the words to protect honesty and integrity in the commercial marketplace. So,
Yes, Your Honor. And it also is it says quite broadly, whenever any person engages in fraud or illegality, whether that is meant to include businesses large or small, because this kind of deceptive risk does cause problems for the honest business people who don't do it this way and don't get the ill-gotten gains. And it does inject risks into the market. I mean, Your Honor, there was probably a time when most of us didn't know what a Repo 105 was, which is what brought down Lehman, or what a RMBS was. And maybe, in an ideal world, the Attorney General or somebody else would have gone in and stopped that fraud and illegality when it was still just among the sophisticated counterparties and before it had the enormous harms and ripple effects that it ended up having.
So let me just ask you, you mentioned about the ripple effect, going on. If the threat of harm or whatever the ripple effect is so remote, does the conduct fall still? I mean, how remote does it have to be? It's the same question with regard to this line drawing in order for the AG to follow through.
I mean, I think the remoteness
or
problem
until
is,
it's
yeah.
outside of the scope of the statute as
Or,
intended?
I mean, I think, at least for 6312 fraud standing alone, I think the limit does come in through the capacity or tendency to deceive requirement. I don't think that the legislature wanted to have this kind of like evaluation about the precise harm out of a specific transaction. I mean, that's why harm is not, I mean, harm is an issue that might be for restitution, but that's not an issue here. But there is a limit, and it comes from the tendency or capacity to deceive standard that this court has put on that does incorporate a materiality-like standard. I think when we say materiality is not required, we're talking about the reasonable investor, that materiality is not required. It's just which objective person you're looking to. There's still an objective standard. So there are...
That's a good point. And so which objective person are we looking to here, given that it is the nature of the transaction that it is? I don't want to belabor the background.
I mean, it doesn't... this court has said that the standard for 6312 fraud standing alone is the objectively reasonable, ordinary, and even unthinking person. But in this case, the court could use the higher standard, and it would be fine. Because
I notice you say the ordinary standard on page 55 of your brief. You say, these deceptive strategies had a capacity or tendency to deceive because they would have been relevant to and likely to mislead an ordinary person involved in the business dealings, and you cite to General Electric. Isn't the test here whether they were likely to mislead Deutsche Bank or Ladder Capital or the City of New York awarding a golf license, or Zurich on a surety bond program, or Everest National Insurance Company on a directors and officers policies? The defendant's statements were not meant for ordinary people. They were directed at some of the most sophisticated individuals and entities in business.
Well, if the court wants to use the standard of an objectively reasonable counterparty, sophisticated counterparty, fine. They had a capacity or tendency to deceive that sophisticated party as well, because these misstatements and omissions were about objective facts that were extremely important and that any reasonable counterparty would want to know. Any sophisticated, reasonable counterparty would want to know that the defendants were valuing an apartment based on 20,000 square feet more than it really was, based on pretending that rent regulations on certain apartments didn't exist, based on pretending that the Mar-a-Lago restrictions didn't exist. Your Honor asked about that. The trial court was very clear that it was not coming up with a magical valuation for itself. The problem with the Mar-a-Lago valuation is similar to what happened with the rent-regulated apartments. The restrictions in the deed are there. They are an objective fact. They are very restrictive. And even defendant's own expert at summary judgment, this is at 16502 of the record, agreed that the restrictions would decrease the value of Mar-a-Lago, but defendants valued it as if those restrictions didn't exist at all.
Counsel, I want to ask my question because your red light is on.
Absolutely, Your Honor.
Madam PJ, is that okay?
Yes.
For the disgorgement calculations, wouldn't it have been more appropriate to calculate them by calculating the difference in valuation of the property versus the valuation provided to the banks to get the loans?
No, Your Honor. The disgorgement calculation, what we needed was the reasonable approximation. What is the reasonable approximation of what defendants' fraud gained them? And defendants' theory is that the guarantee and the financial statements each year were worth nothing. But the point of the guarantee and the financial statements each year was to get the extremely favorable interest rates. And we were not speculating about the difference in interest rates. We had the counteroffer that Deutsche Bank, their own lenders, provided them for a loan without the guarantee and the financial statements. I do, if I could touch very briefly on the statute of limitations, Your Honor.
I think we have it. Did you have another question?
I have a question that's
And I'll
similar
give
to
you
Judge
time for a
Rosado's,
second.
actually, which is the immense penalty in this case is troubling. So how do you tether the amount that was assessed by Supreme Court to the harm that was caused here, where the parties left these transactions happy about how things went down?
Well, disgorgement, Your Honor, looks at taking the gain away from the wrongdoer. And although this is a large number, it's a large number for a couple reasons. One, because there was a lot of fraud. This went on, and illegality. It went on for 7 years during the statute of limitations period. Another reason is because the guarantee and the financial statements each year worked to get enormously favorable interest rate savings to the defendants. It was a difference of approximately 4 to 8 percentage points, obviously varied by year. That is an enormous benefit that they got from the misconduct, and it is not an excuse to say, well, our fraud was really successful, so we should get some of the money.
Was there double counting in the damages assessed for the old post office and the Ferry Point?
No, there was
deals?
not. There was not double counting, Your Honor. Two points on this. First of all, the interest rate savings and the sale profits are separate pots of money. The defendants got the interest rate savings off the top. There's no suggestion that they invested that savings into the OPO. They were using the loan, and so they got the interest rate off the top. That was the savings that they got. Each year, within the statute of limitations, they were getting a savings by doing the fraud over and over again and the illegality. And then the sale profits are separate. And the sale profits, it's not the proceeds. The proceeds of the loan of the sale were around $370 million. The trial court took out the repayment of the Deutsche Bank loan, and I think defendants themselves had taken out already the taxes. And Mr. Trump testified that the number for him, around 126 million in profits, was his profit. That was his profit or more. I'd happy to talk about the statute of limitations quickly, although I see that my red light is on, so.
Well, I'll give you more time for.
Sure, Your Honor. On the statute of limitations.
How much? I'll give you 3 minutes.
Thank you, Your Honor. On the statute of limitations, each use of a misleading statement in business and each issuance of a false financial statement is a violation of the statute. And it is helpful to look at the illegality claims. Every time someone issues a false financial statement, that is a crime, and it is no excuse under the statute of limitations to say, oh, although I issued a false statement in 2017, I should somehow, for statute of limitations purposes, be free and clear because I also issued a different false financial statement in 2011.
Is there any tension between your position and our prior decision that said we have to look to the accrual as of the date the transactions were completed?
No, Your Honor. I think the best reading of that language is that the transactions completed. The transaction is referring to the conduct that the statute is referring to, which is the fraud or illegality. So each time you issue a false financial statement, for example, that is a transaction.
You don't think it's referring to the loan?
No, Your Honor. If the court had wanted to refer to the loan completing or the loan initiating, it would have said that. And Ivanka was much differently situated. The problem, for what this court said about Ivanka Trump was that she was not sufficiently involved within the statute of limitations for her with the certification, preparation, review, or use of the statements. That was why she was released from the case. Whereas the defendants that remain, each personally were involved in the preparation, issuance, and use of the statements in business. And it would really be a distortion of 6312 and this court's precedent in cases like Allen. A similar thing was happening in Allen, where the original relationship between the counterparties started before the statute of limitations, but then new fraudulent or illegal acts were happening within the statute of limitations. And what the trial court said there, and what this court affirmed, was the new conduct that happened within the statute of limitations is timely and actionable, but the things that happen outside of the statute of limitations are not. And I do want to emphasize that neither the trial court nor the Attorney General sought liability based on the fraud or illegality that happened in 2011 or 2012. That is not true. After this court's decision, the Attorney General was not pursuing its claims for the interest rate differential for 2011 or 2012 or 2013. We were pursuing that before, and because of this court's decision, we stopped. And the trial court appropriately separated it and said the claims that are based on fraud or illegality that happened before 2014 are out. And the ones that happened in the statute of limitations period are in.
Do you want to respond to?
Well, I can touch very briefly on the sanctions, Your Honor. I think for the sanctions, I'll say two things. And one is it was not just one frivolous argument. It was multiple frivolous arguments happening, including both at summary judgment, raising the argument that disgorgement is not allowed under 6312 as a categorical matter. That is foreclosed by controlling New York Court of Appeals precedent in Greenberg. And counsel misquoted Greenberg in making that argument to make it seem as if Greenberg had not said what it said. And it was that combined with raising purely legal arguments about standing capacity to sue, raising those arguments again for the third time after the trial court had warned them and said at the motion to dismiss stage, these arguments are frivolous, but I'm not going to sanction you now. I'm warning you. And I understand the need and the feeling to preserve, the need to preserve arguments for appeal. As an appellate attorney, I understand that. But what counsel did here was not write a sentence or two and say, for the purposes of preservation, we are adding this to our brief. They wrote the whole argument again, relying on all the same cases and all the same legal arguments without explaining what, as a factual matter, was different, and that was unnecessary and frivolous.
Thank you.
Thank you.
Mr. Sauer?
Thank you, Your Honor. Just pivoting to that last point, last year, the Attorney General's office was here on the continuing wrong doctrine, making the exact same arguments. This court rejected them and Trump won, and we're hearing the same arguments again, citing some of the same case law. That was sanctionable for our attorneys in the lower court, but here we are. Now, I want to point the court to two citations in the summary judgment record that I think frame a lot of the questions that my colleague was asked. At 13865, there's unrebutted testimony in the summary judgment record that at least creates a disputed material fact that President Trump would have got the same deal from Deutsche Bank if his net worth had been as low as $1 billion. In their calculation, it was never below $3 billion, so it's triple the threshold. And the clear testimony is the interest rates would have been the same. He would have been on they held up a chart that would have been on the same pricing chart. So this notion that there were these 8 basis points at issue is just not supportable. Secondly, at 20,042 to 44 of the record and in other places, the Deutsche Bank witness said, we independently assess all these valuations. We are not relying on the numbers that the client is giving us, but we do our own independent assessment. That is our due diligence. That's the understanding of the relevant marketplace.
I'm sorry, sir, but
Nordbank?
so we're talking now about cause of action number one, the fraud under 6312.
Yes, and the causation argument as to disgorgement. That's
okay.
Yeah.
So we know point taken, as to the liability on cause of action number one, we know fraud under 6312 has a much broader meaning than common law fraud. And so there it's, as your friend pointed out, the standard is the capacity or tendency to deceive. Did those statements have the capacity to deceive?
Absolutely not, Your Honor, for at least 3 reasons. First of all, they're gap compliant. They're not misrepresentations. All the key things they point to is this was wrong and this was wrong. The unrebutted testimony, certainly in the summary judgment record starting at 17,916, is this is what you do in a financial statement. You are allowed to do this. You are allowed to predict, for example, that you'll get your rent restrictions lifted or you'll get authority for, more units at Aberdeen. You're allowed to do that. You're allowed to make optimistic projections. You're allowed to disregard appraisals. What Professor Bartov said is that appraisal could be sitting on your desk and you don't have to rely on it. And there's actually really powerful evidence in this case to show why that's true. Because if you look at 40 Wall Street, they said, in 2011 and 2012, the appraisals of 40 Wall Street were at 200 to 220 million, and you said 527 million. But they overlooked that a couple of years later, Cushman revised its appraisal and said it's worth 540 million, virtually matching what we had said, and they say is misleading. So it's kind of these astonishing issues. It's very similar to the valuation of Mar-a-Lago as $18 million based on a tax assessment. It's preposterous. It's a preposterous position that these factual things. So that's my first answer to that. But secondly, more importantly, we have sophisticated counterparties, as a lot of the questions pointed out. They're getting clear disclaimers. The disclaimers say what everybody already knows you do in this industry. You do your own due diligence. So how is there a capacity or tendency to deceive when you have these very clear disclaimers saying considerable judgment is required here. These values don't reflect what might be realized upon a sale and so forth.
But what about the Attorney General's point that may be true in this case, but we are trying to create a fair and honest marketplace, which will inure to the benefit of the public in the long run?
Yeah, and I would say 2 things in response to that. First, all the questions about line drawing. If this case falls on the other side of the line, there is no line. I mean, you heard, I think for 15 minutes, respectfully, my colleagues struggle to articulate any clear principle that would put any transaction outside the reach of the statute on the Attorney General's very broad and sweeping view. So our position is narrow, which is that on the facts of this case, all these things I've referred to, no reliance, no materiality, Deutsche Bank saying we would have given them the exact same deal, and we have clear disclaimers. Surely this is not within the statute, and if this is, There's nothing that falls outside of the statute, and that is a sweeping and unsettling thing. The second point I'd make about that is...
And I'm sorry, just to tie a ribbon around that, do you mean based on the facts as they were adduced on the respective records, the summary judgment motion as to cause of action 1, the trial record as to 2 through 7? Not that the AG didn't have an interest, at least at the outset, in investigating and maybe commencing the proceeding.
We're not disputing that in this
They
opinion.
certainly have that interest.
You're saying once you got all the facts before the court, which
And that may have been, I wasn't on that case, but that may have been the point of our prior decision, which Mr. Isaac brought up, about this being at the pleading stage. Yes, so it was enough at the pleading stage, but at the end doesn't mean this is what should happen.
That's exactly right, Your Honor. Here we have all the facts before the court.
But the pleadings in this case, I'm sorry, counsel, but the pleading in this case is like a novel. It goes on at length, 327 pages or something like that. And basically, those were the facts that Justice Ngoran found were proved at trial. So aren't we bound by our prior decision? I asked this question in another way before.
Very significant variations. I just want to flag one. I see my red light is on. The pleading, the complaint, cites GAP like 50 times. They said these statements are bad because they violate GAP. But you go to the summary judgment record, they have nothing. They don't put anything on GAP. The trial court never cites GAP. Our experts say these are GAP compliant. That's unrebutted. So there's this totally, the record looks totally different once all the facts are in. And I know my time has expired, so I thank the court for its time.
Thank you.
Your Honor, I'm actually going to go under my time. I just have one observation, and I don't know, maybe I'm wrong about this, but this argument, if it doesn't show why not making a summary judgment motion was appropriate, I don't know what is. There was absolutely nothing wrong with what the attorneys did. My adversary said that she's relying on the Ernst & Young case. I read to you what you said. That's exactly what you did. One more point and I'll sit down. Keep relying on Greenberg. This is what the Greenberg court said, Greenberg 2. Initially, we note that defendants may not raise issues on appeal that were not preserved on the record for our review. So even if they're right about what this court said and they're not right, it wouldn't matter anyway because lawyers have to preserve issues for all courts that may consider it. They have to look at things not temporally at the time, but what could happen afterward. And given that, and I'm not, this isn't Brian Isaac or it's not Michael Ross, I'm reading to you from the court. They did what they were supposed to do. They did what they had to do. To sanction them is just wrong.
Thank you.
Thank you.
Please rise. Being here, over the final passage. This court session adjourned to 2 p.m. this afternoon. Please remain standing. Thank you. You may step out, please. Step out. Oh, you exit. You're really well timed. It's really nice to meet you.